Alcohol and romance really are a bad combination. David Quick and Eileen O'Connell were workmates on the Melbourne trams. They clearly took a shine to one another. One night in April 1948, they were out drinking, and they decided, like you do, that they should get married. Immediately, that night. They somehow persuaded a justice of the peace to sign off on an exemption to the usual waiting period. They collected Eileen's mother, because what girl goes to her drunken wedding without her mother, right? And they found a clergyman, George Glider, who duly began the Church of England's wedding ceremony. Each of them said their vows, and they got to the bit where David was to put the ring on Eileen's finger. She threw it to the ground and said, "I will not marry you," and she ran. So they never got to the bit where the clergyman declared them husband and wife. The question was, were they married? Flash forward a couple of years and David wanted a declaration that they were not married, or alternatively, he wanted a divorce. One assumes he intended to marry again. So were they married? The court split on the question, but the majority said yes. Justice Martin said the pronouncement of man and wife was not required under the Act. He said, as the parties in the case before the court had exchanged vows and spoken the contracting words before the respondent refused to proceed with the ceremony, I consider they were man and wife. Justice Smith said it was essential to a valid marriage in England that there should be, firstly, an agreement between the intending spouses expressed orally, and secondly, the presence of a person in holy orders. I consider that the two requirements stated above, coupled with a sufficient intervention by the person in holy orders, were the only essential requirements, and that no particular forms or ceremonies were necessary. The modern legislation, the Marriage Act 1961, leaves the law in essentially the same position. Under Section 45 of that Act, the speaking of words taking the other person to be the lawful wedded spouse is sufficient in a civil ceremony, and a religious ceremony just needs to be sufficient according to that religion. Ultimately, the question of whether a couple have become married is a question of fact for resolution by the court.